Hey, good morning, everybody. This is John. Hope everyone is doing well, and it's hard to believe that we're already into week three. So hopefully, you guys are having as much fun as I am. I do appreciate the engagement and the discussions. Um, I think it's gone very well so far. So I did make it back from Reno yesterday. I think I told you that I was gone this weekend at the Nevada State Medical Association annual meeting presenting on marijuana laws. So it went well, and now I'm back. So wanted to just discuss some of the reading. I think the reading this week is in chapters 5 and 6. Wanted to discuss some things in there that aren't otherwise covered in the assignment and the discussion question this week. And then at the very end, I'll talk a little bit about the assignment this week and just some tips. So related to the reading this week, I kind of I've broken out my notes on a variety of things that I think are interesting. I think are good takeaways from the reading for the week. So first, I want to talk a little bit about professional responsibilities, and physicians. Really, like all licensed practitioners, are governed by some sort of state board of health or medicine. The nurses in the group are likewise governed by some sort of state board of nursing. Every state has statutes and regulations governing what constitutes unprofessional conduct, and when a physician or licensed provider basically can be disciplined, and that discipline can come in a variety of ways. It could come in the form of revocation of the license, suspension, public censure, educational classes. Really, it depends on obviously what the alleged or the determined unprofessional conduct was. I've defended two physicians. This is years ago in disciplinary actions before a state medical board, and I can't really get into the details. Those are obviously those are probably the best stories in terms of what happened and the facts in the case. But the few takeaways that I can convey to you, particularly those who are licensed professionals in the class, is, and this is just based on my representation of these two physicians, but one, don't ever lie to a patient or a patient's family, and don't mess with medical records. I mean, don't falsify medical records. So that was one case. Essentially, what happened. The other involved some inappropriate comments that were made while a physician thought that a patient was sedated. So unprofessional conduct is defined differently in each state, but I think we all have the common sense enough to know what professional and is professional and unprofessional. So so enough of that. Page 104 in the text talks about patient dumping and a duty to treat indigent patients. I think in prior weeks, either last week or the week before, your reading talked about EMTALA. I think I talked a little bit about EMTALA, the Emergency Medical Treatment and Active Labor Act. To me, that act to me represents the convergence of ethical issues in healthcare and legal issues. And I think as a society, we've determined that turning away those with medical emergencies, turning them away from an emergency room is not what we want to do, ethically speaking, as a society. And so because of that, we have passed, or Congress has, we've elected representatives that have passed federal legislation in the form of EMTALA, and so it imposes certain obligations on emergency departments to provide medical screenings and stabilizing treatment to those that present with those medical emergencies. So, there's a lot of questions. There's a lot of litigation. You could certainly Google it about EMTALA, and and questions about what is an emergency department, what is stabilizing treatment, what constitutes a medical emergency. So there's a lot of federal rules, guidance, and case law about this question, and certainly there's enough information out there to have at least some baseline markers for the answers for those questions. The week's reading talks about patient abandonment a little bit, and it's patient abandonment. Like any other cause of action, has certain elements that have to be met. We've talked a little bit about medical negligence or medical malpractice, and you've seen in your text, and we've talked a little bit about the elements, the four elements that have to be analyzed in a malpractice case. Well, patient abandonment is no different. It's a state law issue. It can either it's either by statute. Some states have statutes prohibiting patient abandonment and explaining what it is. In some states, they don't have a statute, but it's a law based on what's called common law, or how the courts have decided, a case law. And so it's essentially a form of malpractice or negligence that occurs when a physician terminates that physician-patient relationship without reasonable notice or excuse, and fails to provide the patient with an opportunity to find a qualified replacement. It's really, obviously, it's a law or it's a cause of action essentially to protect the patients from this sort of action. Generally, again, like I said, it differs from state to state, but generally, patient abandonment constitutes of 5 different elements that I've written here. The first, healthcare treatment was unreasonably discontinued. Second, the termination of healthcare was contrary to the patient's will or was without the patient's knowledge. 3, the healthcare provider failed to arrange for care by another appropriate skilled healthcare provider. 4, the healthcare provider should have reasonably foreseen that harm to the patient would arise from the termination of the care, or that it's if you sort of compare this with the elements of a negligence case, that would be the causation element. And then 5, the patient actually suffered harm or loss as the result of the discontinuance of care. Of course, that would be the damages or the harm element in a malpractice case. So, like I said, it's governed by state law. Each state generally has laws requiring some sort of notice be given. These are some types of actions that'll may lead to liability for abandonment of a patient based on court cases that I've looked at. Premature discharge by the patient by the physician. Failure of the physician to provide proper instructions before discharge, the statement by the physician to the patient that the physician will no longer treat the patient, physician's refusal to respond to calls or further attend to the patient, and the physician's leaving the patient after surgery or failing to follow up on post-surgical care. So if all the other elements are met, those are situations in the past which have led to some sort of liability for patient abandonment. Finally, we talk a little bit about privacy, HIPAA privacy, and that's not the discussion question this week, but it will be next week. But it is in your reading, and I wanted to just sort of give some thoughts in terms of a precursor for next week's discussion. But generally, HIPAA, which was passed in 1996, I'm sure you're all familiar with it, prohibits at least the privacy piece, prohibits the use or disclosure of protected health information unless an exception applies. And generally, those exceptions involve the treatment, payment, or healthcare operations of the covered entity or the healthcare provider that has the protected health information. So it's obviously, I'm sure you all go through annual HIPAA training. It's something that's very important to be familiar with. There's a lot. Actually, there are some great resources out there published by the arm of the Department of Health and Human Services that sort of oversees and governs HIPAA, which is the Office of Civil Rights. And I'll post this in the actual text of the announcement this week. But great resource. They have great FAQs if you have a specific question. about HIPAA privacy or security rules. Um, that's www.hhs.gov/HIPAA. And again, I'll post that in the announcement. But and there you can also see all the penalties assessed by OCR, the Office of Civil Rights, for violation. You'll see, I think it was back in October, the $16 million Anthem violation or penalty that was assessed for, at that time. I think it still might be the biggest breach in history. So the key is, one of the keys is understanding the definitions of of certain terms that surround the privacy rule in HIPAA. One thing we'll be focused on next week is, the discussion question. There's a question about about a breach, whether a breach occurred, and there are two different scenarios that you're asked to analyze. The question is, what is to me, the question is, what is a breach? And I think it's so important not to go with your gut instinct of what you think a breach may be, because words mean things, especially legal. Breach is a legal term of art. It's a defined term. So the question is, what is a breach? We'll be talking a little bit more about that, but I think that's so critical to the analysis of whether a breach actually occurred. The term breach, as it's defined in the HIPAA privacy rule, is not. It requires an analysis in and of itself. There are a variety of factors to analyze, and there are exceptions to think about and analyze when going through that analysis. So anyways, that was just a precursor. Another thing about HIPAA that I think is always interesting is there's no private right of action. Meaning, if you're protected health information, if there's some sort of breach or improper use or disclosure, you don't necessarily have the right, under HIPAA at least, to go and sue the covered entity or the hospital or whoever the healthcare provider is for that improper use or disclosure. There may be, a lot of states have state privacy laws that are similar, and in some cases more stringent than HIPAA, and the state laws may give you some sort of private cause of action, and it may not. At the state level, a lot of times, the Attorney General for the state is the one who brings the cause of action for those types of breaches. So, anyways, it is kind of interesting how that happens. But obviously, when there is a breach, there are all kinds of obligations that the covered entity or the business associate, whoever is the one who caused the breach, is required to comply with, and to ensure that the risks of that breach are completely mitigated. So real quick, that's it in terms of just discussing the material. Real quick on the assignment this week, it's sort of the rough draft, or remember one of the final projects, at least on the iTraldi case, is an analysis of both the legal aspects of the case, the legal components, and the ethical components. And this week, the assignment is focused on the legal components. So just I can't emphasize enough, make sure you apply specific facts, relevant material, specific facts in your analysis. Look at each section of the rubric. I believe there are 7 sections, and make sure that those sections of the rubric are adequately covered and completely responded to. So, when you get to the legal components section of the rubric, remember that the causes of action and the elements of the causes of action, and remember that while there are multiple defendants in the case, and you were asked to outline those in this past week's assignment, not all those defendants are at issue for our purposes of analysis here. So, but I want you to think about because sort of legal issues, obviously pertaining to Dr. Ricketson for sure, also the hospital, and what the legal components or the legal issues may be concerning the hospital as well. there's a section that discusses malpractice policies. I think students have interpreted this a variety of ways. I think um, generally think about the policies that the hospital had in place that may have or could have prevented the issues that are presented. Some students have also discussed the public policies. I think there's some discussion on that. The variety of state statutes that were in place to prevent this. So, at a minimum, please discuss the policies that the hospital had in place to prevent or at least mitigate the situation. So, anyways, as always, please reach out if you have any questions or want to talk through anything. You're all doing great, so keep up the great work. Have a great week.